Well, thank you, and I do have many questions. One of the things that bothered me, should bother a lot of Americans, and I know it does, is we talk about the reputation of John Yoo and Patrick Philbin, for example, but now we find that Department of Justice email records of both Mr. Yoo and Mr. Philbin have apparently been destroyed. They were not made available to OPR investigators. In just a footnote to the report, OPR states that investigators were told that most of Mr. Yoo's email records had been deleted and were not recoverable. That Mr. Philbin's email records from the crucial period July 2002 through August 5, 2002, the time when the Bybee memo was completed, they also disappeared and are not recoverable. Now, it raises very serious concerns about government transparency and whether the Office of Professional Responsibility had access to all the information relevant to the inquiries. As you know, the U.S. Code is very, very clear about these records have to be retained. In fact, it has the penalties provided by law for the removal or destruction of these records. Now, that's done so the Congress and the American people have a right to know. We also have a right to know, why were these critical records deleted? Why were they kept from the federal investigators? Has the department opened an investigation into the circumstances surrounding the destruction of the emails?
Chairman Leahy, first, the report itself does not suggest that there was anything nefarious about it.
That's not my question. The fact is that the law requires them to be retained. They were not retained. Has there been any investigation into why they weren't retained?
I'm not aware of any.
I don't care whether it's nefarious or not. I just want to know the facts.
Chairman Leahy, what I have done is I have met with the Assistant Attorney General for Administration for the Department of Justice, who has oversight of the administrative operations of the department, which include information technology systems. And I have directed him to work with his experts in information technology to determine what exactly was going on in terms of the archiving of these emails.
Will they make an effort to retrieve them?
I first have to find out what the facts are with respect to the emails. If they're retrievable, I will direct him to retrieve them. That's the part I don't know yet.
I recall when millions of emails mysteriously disappeared during the Bush administration, and I had made publicly said, well, that's, they don't just disappear. They must be there. And I recall them sending their press secretary, Ms. Perino, out to say, what is he, some kind of a IT expert? I mean, that's foolish. They've been deleted. They've disappeared. We all know they've disappeared. Why would anybody suggest otherwise? And then we found the 22 million emails that, of course, had disappeared while they hadn't. They were there. And the federal criminal statutes, 18 U.S.C. Section 641 and 18 U.S.C. Section 2071, prohibit the destruction of these federal records. And I appreciate what you're saying. You got to know what the facts are. Have they disappeared? If they have, and if they have been destroyed, either the Yoo emails, the Philbin emails, will the department make also a determination whether the destruction was criminal?
Chairman Leahy,
violation of the criminal statutes, which seem fairly clear.
Chairman Leahy, what I would like to do, I first want to get the information back from the information technology experts, including all of the questions of what occurred, what the policies are, and what the archive system is. And at that point, I'll be in a position to evaluate whether anything additional needs to be done. I would point out, in addition, though, that the report does include a review of some of Mr. Yu's emails. So I understand, for example, and it makes reference to them, that emails within the department that he sent or may have received would have been to some extent contained in other people's email boxes. All I'm saying is that the report doesn't have a complete lack of his emails, but as soon as I learn the facts regarding this, I will provide appropriate information back to this committee.
It's interesting because, you know, during the firing of the U.S. attorney, something everybody now agrees was an egregious mistake. When we looked into it, there were a number of emails by Mr. Karl Rove and others in the White House that were missing. Now, 2 months ago, we finally find those emails after the investigation was over and after the time when the U.S. attorneys might have been reinstated. Now, I hope we don't have to wait that long this time. And I would hope that what you find, that you will report to this committee, report to me and to Senator Sessions, what you find. We also found that there is a pattern where the political operatives were using a second BlackBerry or non-governmental emails in attempt to circumvent the federal requirements of keeping federal records. Will the Justice Department determine whether Mr. Yu used a second, whether BlackBerry or any other kind of email system, non-governmental emails to communicate with Mr. Addington and others from the White House? Will you determine that?
I will pose that question, Senator Leahy.
And will you give us the answer?
Yes, Senator.
I mean, we all know the famous Shakespeare, the Hotspur. I can call them from the frothy depths, and response, of course, being, well, so can I, so can anybody. But will they come when you summon them? I want to know. I've tried to fulfill this committee's oversight. We made oral requests and written letters, we held hearings, we subpoenaed documents to get to the bottom of what happened. And in fact, I submit for the record a number of letters dated from 2000, 2007, detailing my correspondence, my request to OLC to get this information. We were always told that information wasn't there. We couldn't get it. We would then eventually get a lot of it in the newspapers after it had been leaked by people within the administration, within the Bush administration, and to the press. For example, on October 16, 2008, I issued a subpoena for all documents relating to the legal office of the legal counsel starting from September 11, 2001, concerning the administration's national security practices and policies related to interrogation and detention. I also subpoenaed the relevant index. It wasn't until the end of the last administration we were shown a few of the opinions, then they were heavily redacted. Attorney General Holder released some of these memoranda on March 2, 2009, more on April 16, 2009. But after all this time, I still want to know whether we've seen all the relevant legal documents. So I pressed the department last year, now the new administration, for a complete index of the memoranda. I received a letter last year, June 16th, that they are working to produce the index. The president issued an executive order on January 22nd last year prohibiting the use of any interrogation technique not authorized by the Army Field Manual. An executive order, of course, can be overturned. So my question is this, and I will give